This tutorial provides an introduction to the preparation and filing of expert and witness evidence during court proceedings. Burden and standard of proof. The burden or standard of proof are interchangeable terms used to refer to the legal burden on a party to establish the facts that support his case. Whilst the burden of proof applies to facts, it also applies to evidence, being the burden on each party to adduce evidence that supports his position on the facts which are in dispute. In civil cases, the burden or standard of proof is determined by the balance of probabilities, which in practical terms means to succeed on an issue, a party must establish that it is more likely than not, i.e. greater than 50%, that his or her position is the correct position on the facts as supported by evidence. Let's look at an example now. Your client is a building contractor which has commenced proceedings against a developer for non-payment of sums due under a construction contract. Your client's case is that it is entitled to payment for works undertaken in addition to the contract works. The developer has defended the claim on the basis that there was no agreement your client would be paid for the additional works, and has counterclaimed for the cost of remedying works which are alleged to be defective. To what extent is each party exposed to the burden of proof, and in respect of which elements of the proceedings? Your client is subject to the burden of proving there was an agreement that it would be paid for the additional works, and the value of those works. The developer is subject to the burden of proving the works undertaken by your client were defective, and the cost of remedy. Admissibility of evidence. Evidence can take a variety of different forms and can be crucial to the success of a party's statement of case. By supporting the core statements of case with contemporaneous documentary, expert and/or witness evidence, a party is more likely to satisfy the legal burden of proof and achieve a successful outcome in the proceedings. To be admissible, evidence must be relevant to a fact which is an issue between the parties.